going to call you out each and every time. There is a process. What I do know is, had the roles been reversed, by now, there would likely have been already arrests made. It wouldn't have taken all 6 days, 7 days, whatever amount of days it's going to take. Had the roles been reversed, the wheels of justice spin quickly. Somebody would have been arrested for something by now.
We're not going to talk much in this one, because sometimes the truth doesn't need us standing in the way of it. Today, we're bringing you something different, a real breakdown from someone who actually knows how the system works from the inside. Welcome back. If you've been following the Nolan Wells case with us, you already know the timeline. You know about the missing hours on Horn Island. You know about the phone that turned up wiped clean. You know about the family's fight for an independent autopsy. But this update is different, because for the first time, someone with real legal experience inside the Mississippi court system has stepped forward to give his own analysis of everything that's come out so far. His name is Carlos Moore. He's a Mississippi attorney who previously served as a municipal court judge for over 6 years. And on Friday night, he sat down on his own platform and spent more than 30 minutes walking through what he sees in this case, based on the parents' interview and everything that's surfaced publicly. I want to be upfront with you before we go any further. What you're about to hear is his personal legal analysis and opinion, based on public information. He says this himself throughout. He's very clear that people have a legal right to remain silent, that hiring an attorney is not evidence of guilt, and that everyone deserves to be treated as innocent until proven guilty in a court of law. Keep that in mind as we go through this, because it matters. Moore starts by laying out the basic facts as he understands them. 4 young men went out on a boat to Horn Island on July 4th. Only 3 came home. And according to Moore, none of them reported Nolan missing to law enforcement or the Coast Guard until close to 11 p.m. that night. He then walks through the phone situation, a detail we've covered before, but he adds his own read on it. Nolan's mother tracked the phone herself using Life 360, and it led to the home of one of the young men who'd been on the boat. Moore points out that the phone wasn't voluntarily handed over. She had to locate herself. He also raises a detail about Nolan's Snapchat showing no content from that day, and text messages that appear to have been deleted. From a legal standpoint, Moore says the simplest, most immediate issue he sees isn't a murder case. It's the phone itself. He argues that if Nolan could be heard on video demanding his phone back, and someone had that phone without his permission, that alone could be grounds for a theft charge, separate from anything else in this case. He says if that kind of affidavit had been presented to him as a judge, he would have signed an arrest warrant for that specific issue alone. He also touches on witness accounts suggesting the friend group was seen having breakfast together the next morning, and on the fact that some of them have since stopped speaking to the press and retained lawyers, which, again, he stresses is their legal right, not proof of anything. Now, rather than me continuing to summarize this piece by piece, I want you to hear it directly from him, in his own words, with his own tone, exactly how he laid it out. So for the next several minutes, we're going to step back and let this play in full. Here it is, Carlos Moore in his own words.
We know that at least one of the so-called friends was found with the phone of Nolan Wells. And we know this based on the testimony of the parents, specifically the mother, who tracked the phone and was led to the home of one of the young men where she retrieved the phone. We also know that based on the mother's testimony that Snapchat, there were no Snapchats from the day, which was very odd for her son. We also know that text messages were deleted. We know that when she was tracking the phone, Life 360 said the phone was one place and Snapchat said it was another place. We know that the boy that had the phone did not voluntarily turn it over or call first. He had to be found through their own investigation. We know that based on witnesses' account, the so-called friends were seen on July the 5th, that Sunday, having breakfast together like nothing had happened. They were not out there searching for their so-called friend. We know that the so-called friends deleted their social media, deactivated their accounts, and scrubbed it clean if the allegations are correct. We know that the young man that had the car at his house did not willingly turn over the keys. At first he said that he did not have the keys. He didn't know where they were. Then he, after being pressed by the father, he finally turned over the keys. This is all very suspicious activity. We know that based on an audio recording and some video that Nolan Wells can be heard saying, "Give me my freaking keys." Excuse me, "Give me my freaking phone." And there's been two different versions. Some said he said, "Give me my freaking phone," or some say he said, "Give me my ML phone." Regardless, he was asking or demanding his phone. Someone had his phone who did not have permission to have his phone. So the first thing I see, the simplest thing I see, is who had his phone and why, and was that theft of the phone? Sometimes we look at the largest case, we try to get to murder, but the person that took his phone committed the crime right there. There are witnesses to who took that phone. If an affidavit is signed, an arrest warrant could be signed by a judge in Mississippi to go after that person that had that phone unlawfully. We know, based on his own words, Nolan Wells' words while he was alive, he did not give whoever had that phone permission to have that phone. So was that theft? I think if an affidavit is signed, if it was presented to me when I was a judge, I would have signed an arrest warrant for the person for theft of that phone, based on what I've heard. It'd have to be an affidavit format, but if it was presented to me, an affidavit format from law enforcement, I would sign the arrest warrant for, at least at this point, theft of the man's phone. We know who had it. We know who then reported to the family. The family had to go find it, and we know that Nolan Wells said, "Give it back to him," and evidently it was not given back to him. Why was that? All of the other things I've stated, you piece it together. Is there enough right now for arrest warrants for murder? That is a good question. I do know at this point there should have been search warrants signed by a judge. Evidence should have been presented to a judge by now. We are nearly 7 days after July the 4th, when he was first reported missing. There should have been evidence submitted by Jackson County law enforcement agents, the sheriff's department specifically, presented to a judge so that search warrants could be signed by the judge. And there needs to be, or should have been, someone questioning the young men, the three so-called friends, and others, and the social media accounts need to be searched by now, or at least a search warrant should have been issued for the appropriate entities to give the law enforcement access to the social media information. That should have been done by now. I'm not telling you what I imagine. I'm telling you what the process usually is when you're trying to do a thorough investigation. And based on what's revealed from a thorough investigation, I do believe once the evidence is secured, it's going to lead, and it should lead, to the arrest of one or more individuals for the murder of Nolan Wells. All of the actions are very suspicious, and right now they lead one to believe that one or more persons could have been involved with the death of Nolan Wells. Right now we have a lot of unsworn testimony, but once that is put into affidavit format and there is corroborating evidence through social media, computers, or otherwise, I believe that at that point there will be enough evidence for a judge to sign an arrest warrant. I think critical evidence that's missing right now are the results of the autopsy, the state's autopsy and the independent autopsy. That's going to be critical information. And that alone, or that in connection with what's already known, may be enough to lead to an arrest or arrest. We do know at this point, low-hanging fruit. There should be an investigation about the underage drinking, who provided the alcohol. Those individuals could be immediately arrested based on if there was any sworn testimony presented to a judge. I believe a judge could immediately sign an arrest warrant for those who provided alcohol to underage individuals. There's a lot of people and a lot of potential crimes, some misdemeanors and felonies that people could be held accountable for. Was there any boating while intoxicated? Who was the captain of the boat? And what did he allow on his boat? If there were any illegal drugs possessed by anyone, drugs are still illegal in Mississippi, at least they were when I was on the bench. Drug possession, drug use, selling of drugs, dealing drugs, trafficking drugs. You've heard testimony, or allegations at least. I don't think anything's been put in affidavit format yet about rampant drug use among certain individuals. So there are a lot of things that's been alleged. Once put into the correct format, affidavit-wise, it could lead to arrest for several things, including misdemeanors and maybe even felonies. So there's a lot left to do. We are not rushing to judgment, but I just thought I would come on here and tell you that there definitely should be search warrants issued by now, and there could be arrest warrants for certain crimes issued by now. But for the ultimate crime of murder, it is probably wise to wait to see what the autopsy reveals, or the both autopsies reveal, and then parcel that together with all the video footage, all the witness statements taken, any affidavits gathered, and then make a decision, get it all to a judge at that point, for a judge to decide whether or not to sign a warrant for the arrest of one or more individuals. It would be very interesting to see what the autopsy shows. There's also the potential for kidnapping. It needs to be looked at whether or not they can get to murder. Was there kidnapping? Was this young man taken somewhere against his will at any point? Was there abuse of a corpse even after he died? So there's a lot of things that need to be looked at from various law enforcement perspectives. Law enforcement has to do their job and get the information to a judge in the right format before a judge can act. Had I still been on the bench, if I wanted to act, I could not act unilaterally. I would have to wait till law enforcement brought me the evidence in the right format before I could sign an arrest warrant, before I could sign a search warrant. And so that's how the process works. That's how the process works. And so I am happy to be a retired judge. I'm always going to shoot it to you straight with no chaser. Straight with no chaser. I will tell you the God honest truth. I can tell you this one thing. I may have been born at night, but I was not born last night. And one thing about it, you cannot fool the informed. I've been on the inside. I know the process. And we will not sit quietly and allow this to be swept under the rug. I will call your hand. I will call your hand. You're not going to play these people for a fool. You are not going to play these people for a fool. We know the process. We know what you should be doing. And by God, I plan to make sure you do it. Or we're going to call you out each and every time. There is a process. What I do know is, had the roles been reversed, by now, there would likely have been already arrests made. It wouldn't have taken all 6 days, 7 days, whatever amount of days it's going to take. Had the roles been reversed, the wheels of justice spin quickly. Somebody would have been arrested for something by now. But since the roles are what they are, we are expected to be patient, and they're going to cross every T and they're going to dot every I in the investigation before they make a move, because of the people that are potentially involved. And that's the way the criminal justice system works, unfortunately. If you have access to power or money, in some instances, if you're the right color or the right hue, you will get the benefit of the doubt. And regardless of all of that, based on what I've heard, not in affidavits I've seen, if the affidavits come to support what I've heard, I do believe, especially with the autopsy, once that is in, and then if we look at the body to see if there were any bruises or anything else, it should lead to the arrest of one or more individuals for murder, for accessory to murder, for conspiracy to commit murder, aggravated assault, kidnapping, and a list of other possible things. But right now, I could say that based on that video evidence of him demanding his phone back, someone could immediately be arrested for theft, wrongful conversion of his property. And once you make that first arrest, you start putting pressure on people. It becomes very serious at that point. No one wants their loved ones sitting behind bars, even jail bars, definitely not prison bars. So it becomes very serious at that point. And there are persons of interest that should have been interviewed by now, should have been questioned, picked up, and taken to the station, even if they didn't voluntarily go. There are certain people that should be classified as suspects by now. They should not just be persons of interest. They should be actual suspects. I do not agree with the sheriff saying right now foul play is not suspected. He should have said right now it is too early to tell one way or the other if he was going to say anything and try to be fair and impartial. Because all of this suspicious stuff, the suspicion and the actions of the individuals themselves lead you to believe that something is awry. And the stories are not adding up. The stories are not adding up. So if you believed that he stayed with a young lady, why were you calling the Coast Guard at 11 p.m. at night on July the 4th? And why did the Coast Guard somehow forget that and then remember it? And it's just very strange. And why would you lawyer up before there is even a body found? If my best friend died by drowning accidentally, the last thing I'm going to be doing is hiring a lawyer. I'm going to be too busy grieving my friend's accidental death. And I would not, in my wildest imagination, ever think that anyone would suspect me of a crime. Accidents happen all of the time. All of the time. And one thing about it, if I had been there when he drowned, I would probably been so exhausted from trying to save him that I wouldn't have time to think about hiring a lawyer, or time for my parents to think about hiring a lawyer. And if I am recalling things correctly, I do believe that one of those young people's parents went out to the island. Now, this is a bunch of young folks. I believe one of the mothers got on Facebook and said she went to the island at some point. Why was she there? What was she doing? She was not in their age group. I don't know too many parents that go to a teenage gathering, a young person's gathering. What was she doing? I'm curious to know. I'm not even on the bench anymore, but I'm very curious to know what she was out there doing and who she may have been coaching, or what she may have been an accessory to. It's very odd that she was out there, because I'm sure she was not on the guest list. When I tell you I'm tired, it's because I am. It's time for us to have the knowledge. I got my law degree in 2002. So you're looking at somebody that has nearly a quarter of a century of experience in the legal realm. I spent 6.5 years on the bench. I am not going to mislead you, because too many of us have gone along to get along for too long. I have to meet my makers face in peace. I have to look myself in the mirror. I'm not going to betray you. Enough is enough is enough. I know no one wants to see their loved one go to prison or be held accountable. But if the shoe fits, you might as well get ready to wear it. No one is above the law.
That's Carlos Moore's full breakdown in his own words. Now, let's bring it all together. What you just heard isn't a verdict. It isn't a charge. It's the personal legal opinion of someone who spent years signing warrants and presiding over exactly these kind of hearings. Looking at this case the way he'd look at any other. And even he was careful to draw a hard line. Having a lawyer, staying quiet, none of that is evidence of guilt. It's a constitutional right. And he said as much more than once. But here's what's worth sitting with. Moore's biggest point wasn't about murder. It was about the phone. A simple, specific, provable question. Who had it? Why? And did Nolan give them permission? That's the kind of detail that doesn't require solving the entire mystery of that day. It just requires someone asking the right question to the right person under oath. And that's really where this case stands right now. Not at an ending, not at an arrest, but at a point where more people with real legal experience are looking at the same gaps the public has been pointing to for over a week. The empty Snapchat the deleted messages, the timeline that doesn't match, the silence that followed. Whatever comes next, one thing hasn't changed since the beginning of this story. A family is still waiting for real answers. And until those answers come from investigators, from a courtroom, from evidence, not from any of us, not from more, not from speculation online, this remains exactly what it's been from day one, an open question. If you have any information related to this case, contact the Jackson County Sheriff's Department directly. We'll keep following this. Stay with us.